Today's public hearing will be followed by a classified briefing tomorrow afternoon. This committee last held an oversight hearing on Section 702 in May of 2016. Since then, the drumbeat of terror attacks against the United States and other countries, particularly our allies, has continued. A month after our hearing, a terrorist attacked an Orlando nightclub, killing 50 and wounding 53. That same month, a terrorist detonated pipe bombs in New Jersey and New York, injuring about 30. Last month, Great Britain suffered its worst terror attack in over a decade. A suicide bomber killed 22 and seriously injured many more at a concert in Manchester. Many of the dead and wounded, as you know, were children and very young people. These attacks underscore that the first responsibility of government is to ensure that those who protect us every day have the tools to keep us safe. And when I said government, I should have said of the United States government under our Constitution. These tools must adapt to the technological landscape and the evolving security threats that we face. But at the same time, of course, the rights and liberties enshrined in the Constitution are fixed. They require our constant vigilance to maintain those. Section 702 of FISA Amendments Act, which provides the government the authority to collect the electronic communications of foreigners located outside of the United States with the compelled assistance of American companies, sits at the intersection of these responsibilities. Under Section 702, it's against the law to target anyone in the United States or any American citizen, wherever that citizen is on this globe. The statute also prohibits reverse targeting. That term means targeting somebody outside the United States for the purpose of targeting somebody inside of the country. Under the statute, the FISA court must approve targeting and minimization procedures to ensure that only appropriate individuals are subject to this surveillance. These procedures also limit the handling and use of any communications so collected, and implementation of the statute is overseen by all three branches of the government, including the appropriate inspectors general. After much debate and after much discussion, this law was passed by Congress and signed by President Bush in 2008. The Obama administration requested that it be reauthorized without any changes, and Congress did just that in 2012. Now, President Trump's administration is making the same request. From all accounts, Section 702 has proven highly valuable in helping protect the United States. The Privacy and Civil Liberties Oversight Board found unequivocally that Section 702, quote, has helped the United States learn more about the membership, the leadership structure, priorities, tactics, and plans of international terrorist organizations, and has enabled the discovery of previously unknown terrorist operatives, as well as the locations and movements of suspects already known to the government. End of the quote from that oversight board. The board concluded that Section 02, quote, has led to the discovery of previously unknown terrorist plots directed against the United States and foreign countries, enabling the disruption of these plots, end of quote. Moreover, the board, the FISA court, and other federal courts have found the implementation of Section 702 lawful and consistent with the Fourth Amendment. In addition, the board proposed a number of recommendations in its report to help improve the privacy and the civil liberties protections of Section 702 program. According to the board's most recent assessment report, all of its recommendations have been implemented in full or in part, or the relative agency has taken significant steps towards adopting these recommendations. In 2016, a Heritage Foundation report concluded that 702 is a, quote, critical and invaluable tool for American intelligence professionals and officials, so vital to America's national security that Congress should reauthorize Section 702 in its current form, end of quote. But, as is always the case with policy issues here in the Congress, particularly between the freedom of the American people and our national security concerns, we do have questions and concerns persist for some about Section 702's effect on these civil liberties. Some of these concerns relate to communications incidentally collected when it turns out that a targeted foreigner is in contact with somebody inside the United States or with an American. But of course, there's often no way to know who a surveillance target may be in contact with beforehand. That's in part why they're under surveillance in the first place. And these are situations where the program can be highly valuable by letting our government know if a foreign terrorist plot might reach our shores. Still, the unknown scope of this incidental collection is concerning to many. We ought to understand that. Some are also concerned with the way in which the FBI is permitted to search already collected 702 material. However, it was precisely this kind of information sharing that was recommended by both the 9/11 Commission and the Webster Commission that convened after the Fort Hood attack. Law enforcement needs to be able to connect the dots and do that to protect the American people. In addition, the recent FISA court opinion that admonished the executive branch for its failure to comply with the minimization procedures in some ways ought to be and is highly concerning as well. Finally, there have been allegations that intelligence reports have been unmasked for partisan political purposes. Although these allegations haven't been directed at Section 702 specifically, they're highly troubling. And leaks of classified information that damage our national security seem to continue unabated. I understand that no internal or external review to date has found any evidence of intentional abuse of Section 702 for any reason whatsoever. Nonetheless, it is important that Congress make sure that it hasn't been so abused. And it's equally important that we ensure that the Justice Department has all the tools that it needs to prosecute leaks of classified information. So taking all these things into consideration is one of the reasons and the main purpose for having this, but national security has to be at the top of the list. And so we welcome our witnesses and look forward to their testimony today. And don't forget the classified briefing tomorrow.